Good afternoon, everyone on the webinar. My name is Nathan Archibald. I'm an associate in the Consumer Litigation Group here at Holland & Hart, and I work primarily with food, beverage, and consumer good companies in our Consumer Good Practice Group. So we're talking today about the legal effect that the Americans with Disabilities Act has on how you should conduct your e-commerce. And I'm starting with an assumption, we're talking primarily to direct selling companies here, but, from what I understand, the bulk of your order workflow is conducted on web-based platforms. So in that sense, you're, not too different to any other internet retailer. So let's just start with a quick, for context's sake, just start with a quick thought exercise. Most of you will be on your computers right now, so pull up just your favorite news site. So pull that up, lean back, and just kind of survey that page. And what are your eyes doing? They're probably kind of darting around at headlines and pictures and headlines. You're trying to ignore the ads. You're trying to filter the information. Research has shown that your habits when you hit a website are uncanny. Your eyes fly around, and it all kind of might seem random, but consciously or subconsciously, you usually know where to go, where to look. Now, on that browser, make sure your cursor's in your browser. Can click Control U. So that will bring up the source code in HTML for the page that you're looking at. So that's the code of how the page is written by the developer at its source, and the web browser that you're using, whether it's Firefox or whatever, it renders that big wall of indecipherable text. It renders that into a visual medium, using tags and different codes that you can see in that source code. So that's how, the visually able navigate the web world. But what if you're visually impaired? How do you access information online? There's estimated 8 million visually impaired individuals in the United States who face that question every day. Their main resource to navigate the web is using screen reader software. So that combs through that HTML code that you were looking at, and it tries to assemble it in an organized fashion and will start reading it out loud. And then using your keyboard, you can go from heading to heading across the page, from link to link, until you find what you're looking for. So that screen reading technology is not entirely new. What it relies on is the HTML code. Again, that code, that big wall of code that we were looking at, it relies on that giving certain cues to the screen reader. So, for example, if there's an image, the code needs to tell the screen reader what the image is of. It needs that kind of text description, and some care is needed as the developer is coding the web page to provide that information. If there's an information, if that information is not provided, if the code is not done correctly, then the assistive technology, kind of breaks down and kind of gets caught in a loop. So the question for today is your website legally required to work with this screen reading software? So that has been the battleground question between plaintiffs' lawyers and the defense bar over the last several years. The short answer is yes and no. So let's start by looking at the legal landscape. I've got here on the slide a quote from the Americans with Disabilities Act, which was enacted in 1990, and it's an attempt to create the same sort of civil rights laws that you have for various protected classes like gender, race, national origin. It's intended to provide those same protections for the disabled. So the quote here from Section 12182, no individual shall be discriminated against on the basis of disability in the full and equal enjoyment of the goods, services, facilities, privileges, advantages of any place of public accommodation. So let's just focus on that phrase first, public accommodation. And the question is your private enterprise, which is not owned by the government, is that a public accommodation? And the answer to that is yes. A private enterprise can be a public accommodation. This is from the quoting here from on this slide from the definition section of the ADA. The following private entities are considered public accommodations for the purpose of the ADA. And you see here a big laundry list of the sorts of private entities that are public accommodations. So you'll see there everything from a motel to a motion picture house to a grocery store, a laundromat, all the way down to an amusement park, gymnasium and bowling alley. So there isn't on this list a direct selling company, and there isn't on this list a website of a direct selling company. So that begs the question, is your website a place of public accommodation? If it is, the ADA applies. If it isn't, the ADA does not apply. So the answer to that question, again, is complicated. It depends on what type of operation your website is supporting and where you operate. So if you go back to this list, it was written in the pre-internet world. So the descriptions are all to public physical spaces. So using that language, some circuit courts have read that to mean that only websites that are the online version of one of these, and I'll go back to it, one of these physical places are intended to be covered by the ADA. So a website for a motion picture house, for example, if the motion picture house has a physical location, that website as an extension of that physical location is covered by the ADA. But if the business is solely based on the internet with no nexus to a brick and mortar space, then the ADA does not apply. So that's where some circuits have come out on this question. Other circuits apply the ADA more broadly. They've concluded that Title III is not intended to be kind of stuck in time, and therefore a website need not have a particular physical nexus to a physical space in order to be a public accommodation. The idea here is that the web itself has become the new kind of public space, and the ADA applies here as much as it does in real life. So as an example, Netflix, it doesn't have brick and mortar stores that you go to buy movies from. It's an online service. We go online and stream movies from Netflix. They still, most people don't know, they still do DVD rentals where you can get the little red envelopes. They still do that. But neither of those have a physical store that you go to. So in the Ninth Circuit, Netflix as a web-only business is not liable for ADA compliance, but in another circuit, it is. So let's let's apply that dichotomy to direct selling companies. So does a direct selling company have an actual physical place where sales are made? So that's kind of the point of direct selling. You don't have a retail space. You have decentralized distribution. You're everywhere and nowhere all at the same time. I mean, that said, some direct selling companies do have physical stores. Probably where like Herbalife has these kind of nutrition clubs that use traditional store fronts. So there hasn't been any cases which kind of define this for direct selling companies, but the reality is that direct selling companies are more like Netflix, purely online entities. There are tens of thousands of real life distributors who live and breathe outside of the website. But there are a number of cases that have determined that having those sort of independent contractors as an extension of your web business is not enough to make the website a public accommodation. So the cases on that point are Uber, and as you're probably aware, Uber has its web presence, it has its app, and it also has physical drivers out there in the world. So the fact that there are these independent Uber drivers was not enough to make Uber itself a public accommodation under the ADA. The same with eBay. eBay has millions of users who use their platform to sell online. Again, the fact that they exist in the physical world doesn't mean that the website does. So to answer the question, is your direct selling website a public accommodation? Well, the answer is, it depends on where you get sued. I think I noted so if you look at this map, this is a map of the different circuits. If you're in the 3rd, 5th, 6th, 9th, and 11th circuits, so the 9th is a big one there that covers, California mainly, the 11th down in Florida. In those circuits, no, your website is not covered by the ADA. In some circuits, though, the 2nd, for example, where the ADA is applied more broadly, yes, you are a public accommodation. So again, the answer is complicated, depends on where you get sued. So for example, the 2nd Circuit covering New York State, yeah, you can be sued there. So let's talk about the risk of getting sued. So a remarkable kind of little cottage industry has flourished in the last several years. So plaintiffs' lawyers are suing companies for failure to have an accessible website. And these are the numbers from the last several years. And you can see the numbers themselves and the increase year over year are quite staggering. So just a few things to bear in mind about these numbers. It's literally only a handful of plaintiffs' firms that are generating these thousands of cases. So there's literally 5 or 6 firms in New York City, 5 or 6 firms in LA County and Orange County that are responsible for all of these cases. Those numbers don't include state court. A lot of plaintiffs will file in state court. So, if you go back to these numbers, perhaps double them again to get the total between federal and state court. Now, these cases are filed regularly, but they're infrequently litigated. By that, I mean over 90% of cases just that were filed in 2018 have already settled. But if you look at the numbers there, if you look at kind of, perhaps 4,000 cases a year, the average settlement is about 15,000 and the average cost to defend is about 10,000. You're talking here about $100 million a year hit to the business community. But, your concern is not the whole business community of the United States. Your concern is your company. And, when you think of the idea of, 100 or a couple of 100,000 of e-commerce target companies, 3,000, 4,000 lawsuits is, a small percentage. But that said, we've already seen a number of Utah clients being sued, including direct selling companies. So, the reality is, if companies are not taking precautionary measures now, it is likely a matter of when, not if, they get sued. After dealing with, plaintiffs' lawyers in this arena for the last several years, the sense that I'm getting is that the plaintiffs' bar is emboldened. They're making good money from these suits, and the numbers of their filings are increasing and will expand, and more lawyers will get in the game. So I think these numbers will expand, some think even explode. So that's the risk of getting sued. How do you avoid that inevitable? Well, the answer is easy. If you have a website that does not discriminate, then you can't be sued. The problem is that it's not so easy. The internet it's a visual medium. So by definition, it discriminates against the visually impaired. So that said, the ADA does not require a perfect world. It requires a place of public accommodation to make reasonable modifications of its policies, practices, and procedures to furnish appropriate auxiliary aids and services where necessary to ensure effective communication with individuals with disabilities. So again, you don't have to make the world perfect. You just have to provide reasonable accommodations and appropriate auxiliary aids. The Department of Justice, which is the agency that regulates the ADA, has emphasized that auxiliary aids and services, as referred to in the ADA, includes screen reader software or other effective methods of making visually delivered materials available to individuals who are blind or have low vision. Again, I guess it is easy then. All you have to do is make your website compatible with screen reading technology. That's a recognized auxiliary aid. But again, it's not so easy because the Department of Justice does not tell us how to provide that accommodation, which is surprising. You'd think that the Department of Justice has had a long time to think about this issue, and it has not yet released a set of benchmarks on what a reasonable accommodation standard for websites is, or how to accomplish it, which is problematic. The Department of Justice also regulates the Americans with Disability Act for physical buildings and builders, and it has, very, very long documents that describe how to design accessible buildings, and it goes into the granular level, describes even, what the maximum carpet pile length is, so that it's suitable for people with wheelchairs. They have not done the same for websites. There was a hope that they would do so back in 2010. They issued what's called an advance notice of proposed rulemaking, which is essentially their public statement saying that they're working on it. That was in 2010. Not much happened after that. They didn't get past really the exploratory stage. And in 2017, they withdrew the proposed regulation altogether. I have a quote here on this slide. This is the latest from the DOJ. This is from a September 25 letter that the DOJ sent in response to House members who were specifically requesting clarity from the DOJ on unresolved questions about the applicability of the ADA to websites. And this is their response. Absent the adopting of specific technical requirements for websites through rulemaking, which hasn't happened, public accommodations have flexibility in how to comply with the ADA's general requirements of non-discrimination and effective communication. So unfortunately, the DOJ's response right now is they are flexible. When you're making plans with friends, when they say they are flexible, that's a good thing. It gives you lots of options. But when the DOJ says that their rules are flexible, that's a bad thing. They are saying essentially, we don't know, you guys figure it out. What that means for companies with websites is they have the worst of both situations. They have the mandate, but they don't have any rules or instructions on how to reach that mandate. So what is the WCAG? That's probably something you've heard your web development team talk about. The Worldwide Web Consortium, W3C, that is an international body that develops open standards and guidelines for web developers. One of their guidelines is the Web Content Accessibility Guidelines, the WCAG, which contains their set of recommendations for making web content more accessible, and not just for the visually impaired, for all sorts of disabilities. Their most current version of their guideline is WCAG 2.1, which was adopted in 2018. And as you go through this guideline, they describe everything in three kind of levels of compliance: A, AA, AAA. AAA being the most detailed and thorough. Now, the WCAG, it's written by people who code. So everything they provide is not just kind of abstract information. They provide actual, testable success criteria. Now, I won't go through them all. There's, 61 different tests that you can run on your website to see if it's accessible. But here's just a kind of a sampling of some relevant ones. And these are ones that we see most often in complaints from plaintiffs' lawyers. So success criteria 1.11 requires images to be coded with information that a screen reader can use to orally describe the image. Because, of course, someone who's visually impaired can't see what the picture is of unless it's described to them. Success criteria 2.4.6 requires headings to be consistently arranged, programmatically arranged, so that they adequately, describe the content under the heading. And the point here being so that someone who's visually impaired can navigate around on their keyboard through these headings, and they can use those headings as kind of signposts of where they're going. The third one here, success criterion 3.3.2, it requires that, when you have input fields, the screen reader needs to be able to describe the data that is expected in that field. So you have a form, it's got multiple fields for a name, address, credit card number. The visually impaired person needs to know which field they put their name in, which field they put their address in. And you can understand without that ability, you can't complete a purchase workflow. So hopefully I've been clear on this. This is not a agency regulation. It is simply a set of industry best practices. But nonetheless, it has been kind of de facto adopted as a legal standard. So when you're arguing in court over whether or what a company has to do to make its website accessible, often the WCAG is the standard that courts require companies to live up to. So the positive takeaway from that is that a website owner can take some comfort that, if they're complying with the WCAG scheme, they have a defensible case that their site is ADA compliant, even absent anything concrete from the Department of Justice. But what are the problems with having this industry, this industry standard as a de facto legal standard? Well, firstly, it is just an industry standard. It's not vetted by regulators. It's not passed by lawmakers. It's not weighed against public policy. And the second problem is that it doesn't really answer the question raised by the ADA. The ADA requires a reasonable accommodation, and these success criteria, they're not answering that question as to what a reasonable accommodation is. So, let me give you an example. The success criteria are designed to allow those using screen readers to get to information as quickly as possible. So if you have a design feature that has the effect on a screen reader of perhaps slowing it down, providing perhaps more information that the screen reader needs, if it doesn't prevent the person from ultimately getting to the information, it's just kind of slowed them down, is that an ADA violation? Well, arguably not. Is it a WCAG violation? Well, yes, because it's failed that success criterion. So the problem is if you have courts measuring ADA compliance solely by reference to WCAG compliance, then you've got a mismatch there. You've got courts that are looking beyond the law or looking beyond the mark. I've got a quote here from the DOJ who does recognise this problem. They've recently confirmed non-compliance with a voluntary technical standard for website accessibility, that's the WCAG, does not necessarily indicate non-compliance with the ADA. But the problem is, because you have this standard, this WCAG standard, and because it has these easily testable criteria, plaintiffs' lawyers are simply basing websites on failure, on WCAG errors, and they can determine those errors very easily by using, off-the-shelf software which scans your websites. So they're conflating WCAG errors with ADA compliance, filing their complaints, in good faith, arguably, because it does fail the WCAG. But like I said, the WCAG failure does not necessarily mean an ADA violation. So you can see the problem there. People are getting sued, perhaps when they shouldn't be. Okay, so let's skip to the important question: how do you avoid getting sued? Well, number one, you can make sure your website complies with the WCAG success criteria, even though, as I've disclaimed, that is not strictly a legal requirement. You can use the same website scanning software that the plaintiffs' lawyers are using. They use software like PowerMapper and DynoMapper. And if you can make your website invisible to those tools, then fingers crossed you can be invisible to the plaintiffs' lawyers. You can conduct a third-party audit. There are many companies out there that are offering that service. Some are better than others. You can also make sure that all your plugins and platforms are compliant. And by that I mean, if you have like on your e-commerce site, if you have like a Shopify type platform that looks like it's on your server side, but it's really a third-party platform, make sure that company is also WCAG compliant. We've done a bunch of these cases for like restaurant companies, and you'd be surprised. Some of the well-known order payment platforms that restaurant companies are building their websites on are not ADA accessible. You can post an accessibility statement on your site, which articulates that you're working on compliance, and that may be enough to dissuade a plaintiff's lawyer from suing you. And these are some other things you can also do. You can include, if you're using an external web developer, you can include an indemnity from suit in that agreement, so it kind of shifts the burden to the developer to make sure what they're developing is not going to get you sued. And you can also talk to your insurance broker. This sort of coverage is inexpensive or even a free rider on a lot of policies. So the next question is there any legislative or judicial action that will save us from this mess? There was a bill last year in 2018, the ADA Education and Reform Act, that would have amended the ADA to force prospective plaintiffs to give you written notice before they filed suit. Something like a 60-day notice period. And within that 60 days, a company would have had the ability to fix their website, fix any of the problems. So essentially, it would have been a kind of a baked-in cure period. And with that cure period, that could, potentially stop the majority of these suits. So that bill passed the House and it got to the Senate and became clear that it wasn't going to be filibuster-proof, and so it was dropped, and it's probably unlikely to become law anytime soon. In New York State, they're proposing some similar legislation. New York is one of the places where, at least a third of these cases are being filed. The other fix on the horizon, Domino's Pizza, they recently lost in the Ninth Circuit. They were arguing that these ADA suits, violate due process rights. They lost at the Ninth. They won at the District Court. They lost at the Ninth Circuit, and now they have filed for certiorari with the Supreme Court. A number of business groups have supported that bid for certiorari with amicus briefs. So this question, or multiple questions about ADA web access, may be taken up by the Supreme Court in the next term. So that may provide some sort of fix here. So let's say that you are like the thousands of companies out there that do end up with a lawsuit on your desk. So how do you respond? Well, bear in mind, over 90% of these settle. And when I say over 90%, I'm kind of hedging there. I really mean 100% of these settle. Well, 99.9% of these settle. They're built to settle. Plaintiffs' lawyers don't want to do any actual work to litigate, and most companies either have no interest or incentive to litigate these. Most settlements are for a modest amount. We are seeing, though, that the dance between plaintiffs' lawyers and defendants' lawyers here is a market like any other market. People know intuitively, after spending some time in the market, what the right price is. And we're seeing over the last couple of months that the market price is increasing. So that's something to bear in mind. Particularly, when you do get sued, don't be shy in communicating with other companies, and make sure you've got experienced defense counsel who know what the market price is. Because unfortunately, as the scope of these cases expand, and they land in the hands of people who haven't been in the market as long, and if you have a defence counsel who's willing to settle for a higher amount, then that's going to it's going to gradually start bumping up the market price. The most important thing to remember that when you settle one of these cases, which if you receive one, you probably are going to do, is that it's a private settlement and it has no preclusive effect against other plaintiffs. So you're really, for the amount that you're paying to settle, you're not getting much in return. You're getting an agreement that particular plaintiff, that particular visually impaired person, will not sue you again. They will sign a release that says that. But there's nothing stopping the same plaintiff's lawyer from suing you again with a different visually impaired person. Now, that doesn't tend to happen. There is, a concept of honour amongst thieves that the plaintiff's lawyers are not going to go back to the same well. But that said, because the number of plaintiff's lawyers here are expanding, we're starting to see multiple lawsuits against the same company because these plaintiff's lawyers aren't talking to each other. We've seen some companies, just here in our, Rocky Mountain area, get sued in the same week by different plaintiffs' firms. Okay, so the answer to the question is how to respond to the lawsuit. Most likely you're going to settle, but like I said, please bear in mind you're not buying much. You're not buying much protection from that settlement. The next question is, do I want to push back on settlement? Am I the sort of, does our company just roll over to these demands? If not, what are our legal options, our legal arguments? I've outlined some of them here. These are the arguments that most defence counsel will make if pushed. The first one here is mootness. The idea here under the ADA that the remedy really is injunctive relief. To have a court as a remedy tell you to, change your website. But if you're already in the process of doing that, or if you've already really completed that, then an injunction is unnecessary, and thus there's an argument that the whole cause of action has been mooted. Now, some courts accept that argument, but it is becoming rarer. The second argument is primary jurisdiction. Now, this is the idea or a judicial doctrine that a court is not in a position to regulate what agency standards apply to companies. So in this case, that would be the DOJ's job. So the court, out of deference to the DOJ, should stay the proceedings and let the DOJ sort it out. Now, early on, courts were willing to stay or dismiss these ADA cases under the primary jurisdiction doctrine, but now, as we've kind of gone through, the DOJ has seemingly abandoned its efforts. Courts are now less willing to defer to the DOJ because they're not doing anything. Due process, is an argument that, for example, Domino's made at the Ninth Circuit. And this is the idea that, can a court really hold a company in violation of the ADA when there are no legal technical standards to measure their compliance? It's a good argument. It didn't win the day for Domino's, and it may be too esoteric an argument for most trial courts to get behind. The next thing is attack the messenger. You might have seen this in some states, ADA plaintiffs who do these kind of drive-by filings against physical storefronts. they're filing hundreds or thousands of these. And some states' attorneys generals are pushing back against that, even sanctioning those attorneys for these drive-by cases. No state has really taken up that against these website, they call them surf-by plaintiffs. So no state attorney general or no set of defendants has really taken that up yet. But as the field expands, that we may be ripe through that. The next thing in attacking the messenger, maybe if defendants would coordinate, because you'll have one plaintiff with one plaintiff's attorney filing dozens of these a week. Now, if those defendants could coordinate, get together, move to consolidate their cases, that would put a real dampener on the plaintiff's world, because now they'll have one case and one set of attorney's fees rather than 50. You can also push back on the merits. You can, but these are kind of fact-intensive arguments. You can push back, for example, in summary judgment and argue that your website is substantially accessible and that the company's actions were a reasonable accommodation. You could argue that you had alternative access. For example, let's say you have a toll-free number that customers can call to get information or place orders. And whether a toll-free number is a reasonable accommodation, that is still an open question. That hasn't, there haven't been courts that have denied that argument. You could also push plaintiffs' lawyers, try and push them around a little bit, go through discovery, try and find out through discovery, is their named plaintiff actually a bona fide user of the website? Were they a bona fide purchaser? What actual barriers did they encounter? But again, these are anything where you're trying to get to the merits or going through discovery is a fact-intensive, expensive exercise. Like I said, most of these cases are built to settle, and most of them do settle. And sometimes, really inexpensively. I've had, some experiences where with plaintiff counsel where the settlement phone call is literally 3 minutes long because plaintiff's counsel is reasonable and they're not trying to extend past kind of settlement instructions. So sometimes these can get resolved very quickly, and for a modest amount. So that's the main part of the webinar today. How, why, how to respond to these ADA websites. We do have a couple of minutes left before we turn into pumpkin. So let's open for any questions. Let me click on the question button. And yeah, let's go to Q&A.
Okay.
The first question is, which WCAG guideline should I seek to comply with? Okay, so just going back here, I think I mentioned there are 3 levels of WCAG compliance. This is a difficult question. Courts are not consistent. Some courts have accepted, AA compliance as their injunctive remedy. There really isn't. With web developers, if they're starting to go through WCAG, there isn't that much difference to them in complying with level A and AAA. So, in order to make yourself as invisible to plaintiffs, lawyers, software as possible, we always recommend the highest level, AAA. And the next question, how much should I settle a case for? This is a difficult one for me to answer because most of the settlements that we do have confidentiality riders in them. So I can't get into specifics on any particular case, but let me couch it like this. Most lawyers will tell you that the market is, somewhere between $8,000 and $20,000 for a regular, mid-sized national company. And most settlements will fall somewhere in the middle there. Plaintiffs will file their complaint and serve it on you, and they will quickly make an initial demand. And for some reason, the initial demand is always like $38,000 or $40,000. And I'm not sure why plaintiffs have settled on that number as their opening gambit. But the point of the exercise is to just get them down from their initial demand. So there's no more questions. So let me just pose one for you. If it's only going to cost $20,000 or so, by the time you pay the settlement amount and your defendant counsel and the time it's taken with your in-house counsel, when you wrap it all up and it's a $20,000 exercise to settle, should I take precautionary measures? Should I just kind of let it ride? So, after talking with your web team, if that's where the cost-benefit analysis leaves you, then by all means, that's your prerogative. I would say though, there are some externalities to take into account as well. There may be PR benefits from having an accessible site, and if you do things correctly, you'll very clearly state that on your website. So there are some PR benefits to that. There's also some PR costs in being sued for not having one, even though there is a route to make the lawsuit go away quickly. The other problem is, like I mentioned earlier, we are seeing clients getting sued multiple times, multiple suits even in the same week from different plaintiffs' lawyers. So it's not just the cost of one settlement that you've got to take into account. Perhaps there's going to be multiple settlements that you're going to have to go through. So that's it for the Q&A. We're kind of right on time here. I don't see any further questions online, so let's wrap it up. I'm going to the last slide. So that's a picture of me that is very much out of date. So yes, if you have further questions on this ADA world, how to wrangle your web team, how to respond to a lawsuit, then by all means let me know. I'm happy to take questions offline. And with that, thanks for joining us, and have a good afternoon, everyone.